Okay, good afternoon, St. Louis. Welcome to our presentation today about how to obtain a U.S. patent. Before we get started, we'll just go over a couple of administrative things that are on slide 2. We'll be recording today's presentation, and at the end of the presentation, we'll be happy to send a link to the recording and copies of the slides to all the attendees. During our presentation, we definitely welcome questions. So if you have any questions, please type them in the Q&A box, which on my screen shows up at the very bottom, kind of in the middle. And if you just want some general chatter, chit chat, feel free to type that in for the entire group in the chat box. And just to kind of get things going, if you want to test it out, love to hear what you have to say about St. Louis's famous Provel cheese. What do you think about the cheese pizza at Emo's? Is it really good, or is it just glorified cheese and crackers? So let us know what you think about that. And finally, don't forget to follow us on social media. Check out our LinkedIn feeds, as well as slwip.com for other webinars and other information about IP, etc. I do see today is Veterans Day, so hats off to all of our folks, our friends in uniform, and thanks for your service. I'm your host today. I'm Doug Portnow. I am a registered patent attorney at the law firm Schwegman, Lundberg, and Woosman. I'm pleased to announce that starting next semester, I will also be on the adjunct faculty teaching law at the University of Hawaii Law School. I did work at a couple other big law firms, which you can see there. And currently my practice focuses primarily on patent prosecution in the mechanical and medical device technology areas. And I also do a lot of due diligence to help startup companies get through the fundraising process. I have a law degree. I also have an MBA, and I have 2 engineering degrees. And before practicing law, I spent about 10 years working actually in the medical device, designing various surgical and medical instruments. And just a random fact for our audience, in case you're curious, I once auditioned for the TV game show Jeopardy! And if you want to know how that turns out, join one of my other webinars and we'll talk about that. My co-host today is Aris Gregorian, also a registered patent attorney at the SLW law firm. And he primarily focuses his practice on software and apparatus patent inventions. So I know in St. Louis, we've definitely got a lot of high-tech inventors and entrepreneurs. So feel free to ask Aris any questions that you may have. Aris has his law degree and also an electrical engineering degree. And he's also worked with a lot of startup companies. And just a random fact about Aris, when he's not working hard on patents to protect inventions, you'll find him, or recently found him, at games 3 through 6 of the World Series, where he saw the Atlanta Braves win it. So I'm sure he'll have some interesting stories about that. And just a quick overview of our episode today on slide 5. We're going to just be covering, what a patent is, what a patent is not, because sometimes there's some confusion about that. We'll talk about why patents are important, especially for startups. And we're going to really focus on how to prepare and file a patent application and the process for obtaining a patent application, for obtaining a granted U.S. patent. We will talk about the legal requirements for filing and obtaining a patent, and then we'll talk about some other related issues like patent validity, what to do if you're involved in litigation over a patent, and some other portfolio management issues. So with that, before we start these talks, we always like to just kind of give you a high-level overview of the different types of IP, and Aris is going to take that.
Yeah, I'll get started here. So really happy to be speaking with all of you. So there are generally 4 types of IP that people refer to when they refer to intellectual property. So first, we'll say trademarks and service marks. So that would be like Nike, Coca-Cola, McDonald's, any word, phrase, or symbol that identifies or distinguishes a source of goods. So that also includes phrases. So like the phrase, just do it, or I'm loving it from McDonald's. Those will all be protected by trademark. Then we have copyrights. So that would be to protect original works of authorship. So the next great novel, that would be protected by copyright. Music is typically protected by copyright. Photos, sculptures, a lot of artwork, stuff like that. Then trade secrets. So that would be essentially anything that you can keep secret and you would prefer not to share with the public in any sense. So famously, I think the Coca-Cola formula and the KFC secret recipe are both protected by trade secret in that there is no formal form of intellectual property protection. Those things are just held very closely by the corporations. And finally, patents, which are the subject of discussion today, and that is essentially a limited monopoly on some invention for a limited period of time. So let's see, let's go to the next slide and we'll start getting into patents. So for a discussion on patents, I think the best place to start would be to talk about the types of patents that are available and that you can get. The type that you will need obviously depends on what you're trying to protect and what type of startup we're talking about. But in general, so we have utility patents, design patents, plant patents, and then utility models, which are kind of a different thing altogether. But so in general, when somebody refers to a patent, they're usually talking about a utility patent. So a utility patent is a patent that covers the creation of any new or improved or useful product, process, or machine. And basically that would prohibit other individuals from making, using, or selling that invention without authorization. Then we have design patents. So that is focused just on the ornamental aspects of something. So that would be a form of legal protection on the unique visual qualities of a manufactured item. So the shape of a lamp might be protected by a design patent. Then plant patents, which are less common in my personal practice, but they are a thing. So that is intellectual property that protects new and unique plant characteristics. So it can be a natural bred or somatic plant, which is something created from non-reproductive cells. Yeah, so then finally we have utility models, and that's like a patent. They are available in a lot of countries, but notably not in the United States. So that may not be applicable to anyone here. Generally, I think it's looked at as like a patent light, not really quite as powerful as an actual patent. They're usually cheaper, but that is just another option. So go to the next slide. So what a patent actually is. So I think to describe what a patent is, I think it's kind of important to say what it's not. And so what it is not is the right to automatically practice whatever your invention is, because depending on what your invention relates to, there could be other regulatory bodies that are involved, like the FDA. So if you have a patent on a new drug, the Food and Drug Administration is obviously going to want to be involved. If you have a patent on a new form of meatless patty, the Food and Drug Administration is going to be involved. So just having the patent for something doesn't automatically guarantee you the right to actually go out and practice the invention. What a patent does do is it gives you the right to exclude other people from making, using, or selling that invention for a limited period of time. So if you get a patent for something, it doesn't automatically guarantee that you can go out to market with that thing, but it does enable you to go out and stop other people from producing or disclosing that thing. So on the next slide, we will talk about some reasons that you may want to obtain a patent. So obviously, because patents are important, that's the main reason why. But you can basically, as I said, you protect your invention by excluding others. So in many instances, you want to be the only person that has the right to produce something, and that is the entire reason that you would go out and get a patent. If Snapchat, for example, didn't have the ability to exclude others from ephemeral messages, that would have probably hindered their growth early stage. So it's important that early stage startups are able to protect their distinguishing and their main features through the use of intellectual property by excluding others from being able to practice those things. Intellectual property and patents specifically is property that can be monetized. You can license it and sell those things. That's another important reason. That comes in to consideration when a company is being evaluated. They will look at the patent portfolio, see how much of the company is protected, or how many of the features or products that the company has are protected by IP. It's also kind of in the context of fundraising. I think a lot of VCs and investors may look at a patent as proof that you actually have something of value. It's sort of like a validation that this thing that you've been working on is patentable. It's actually novel and unique from what actually exists out there. So there's many different reasons that an early stage startup or a company would want to or need to acquire a patent. And I think the next important question, and probably the reason that many of you are here today, is how do you actually get a patent? So obviously you file a patent application, but what does that involve? So we'll get into that. But on the next slide, and the following slide, we're going to get into the anatomy of a patent. So what are the parts of a patent? So what does a patent include? So if you have looked up a patent application online on Google Patents or wherever, I think they can often be somewhat intimidating to look at, just because there's a lot of different, it looks like a lot of important legal stuff going on there. But I think if you just kind of know what each of these components are, they're not so intimidating, it's just formatted funny. So a patent, and there's an example to the right there of a portion of a patent. A patent has an abstract, a background, a summary, figures, detailed description, and then claims. So in general, you have a spec, claims, and figures. Those are the three biggest parts. So the abstract is basically the thing that you see at the front end of a patent. On the right side of the screen here, you can see far right, there's a little section labeled abstract. So that's basically just a very brief summary. I think it's can't be more than 150 words in length, and it just contains a summary of the disclosures containing the description, and it just is generally to enable the patent office or whoever's looking at the patent to kind of quickly determine at a kind of cursory glance, like, what is this thing related to. Then once you get down to the background of the invention, so this is not a required part of a patent application, but the background of the invention is usually just to kind of set a context for what the invention may relate to. So it might just explain that the patent relates to, maybe it's related to the automotive field, or maybe it's related to, surgical devices, or specifically a type of surgical device for a specific type of procedure. It just gives a background statement on the area and technical field that a patent may relate to. The summary of invention is a brief summary indicating the nature and substance of the patent, which can include kind of a statement of the object of the invention. And also, it's not a required section, but it just kind of, again, sets the stage for what is described in the detailed description. The patent figures are essentially just a set of drawings that describe and further support the specification, to provide support and to provide a means of more clearly describing something. And then finally, the detailed description and claims. So the detailed description is the bulk of a patent application that you see is the detailed description. So that is basically to fully disclose what the invention is, how it's made, how can it be used. You generally have to explain the enablement section here. How do you actually do this thing, whatever it is? You will typically need to explain the best mode that you envision for the product or invention. And then finally, the claims. Those are mostly a legal thing that essentially define in kind of technical legal terms the scope of protection that you actually receive. The claims will change through prosecution typically, but those are the purely legal part of the document where it defines what it is that the patent owner actually owns. So on the next slide, So now we'll get into a discussion of what is patentable subject matter along with what the statutory requirements are. So this may not be immediately relevant depending on the stage of startup you guys are at or whoever's at, but in general, the subject matter is defined by the USPTO under Section 101, and once subject matter eligibility is determined, then you have the question of novelty and non-obviousness, which are dealt with in sections 102 and 103. We will get into what that actually means, but on the following slide, without getting into too much of the statutory stuff, what is patentable? You can patent anything man-made. You can't patent laws of nature or naturally occurring things or abstract ideas, but you can patent anything else that has been man-made. That can include device claims, medical method claims, manufacturing claims, system claims. So that means that your patent could cover a device. You could patent a method of manufacturing the device. You could patent a system that has multiple devices involved, but then you can't patent, obviously, a law of nature or an abstract idea, which would be essentially trying too broadly to get a patent that covers just the idea of something alone. You have to actually patent the product and how it actually fits into your invention. So on the next slide, we have a discussion on novelty. So novelty says that a person shall be entitled to a patent unless that claimed invention was already patented or already described in a printed publication or has already been in public use or sale. So I think it's basically just that you are not copying someone else, that your invention already or does not already exist. That's really the question. So on the following slide, I think the US is what's known as a first to file system, where essentially whoever files the patent first is the person that is the patent owner. Previous to the America Invents Act, there was a way that an inventor could essentially claim that they came up with their invention before a patent was filed. But there's obviously a lot of complications around doing that, and there's proof and issues. So America went to the first to file system, which is a lot easier. There's no geographic limits. There's just one date to consider, which is the filing date of the patent application. And if there is a public disclosure, if you as an inventor disclose something publicly, you get 1 year to go out and file a patent before you lose that option. So we have an example of, Doug, do you want to do this novelty example here?
Yeah, sure. Yeah, if we could just get that on the screen. Thank you. Okay. So example 1 is a little bit of a hypo. So let's say your invention is a chair with 4 legs, and you do a search, or the patent examiner comes up with prior art. Maybe it's a magazine article or another patent that teaches a chair with 3 legs. So here, the difference being your invention has 4 legs versus 3 legs in the prior art. Therefore, you have novelty. The novelty is the 1 extra leg. These are very simple, but just really to illustrate the concept. Example number 2, let's say you invent a chair with 4 legs and a back support. So, and again, let's say the patent examiner or you are aware of prior art that teaches a chair with 3 or more legs, but doesn't say anything about a back support. So there, if you kind of parse it out, the back support feature is novel. And also the combination of the 4 legs with the back support is also novel. So just a couple simple examples to illustrate the point. Back to you.
Yep. Okay, so we've discussed patentability, novelty, and now on to obviousness. So next slide. So obviousness is the idea that if an invention is obvious to either experts or the general public, you can't patent it. So basically, to determine whether or not something is obvious, we have this kind of four-step test that I have here. So one, where you're going to determine the scope and contents of the prior art. So you're going to look and see what's out there, what already exists. Two, you ascertain the differences between the prior art and the claims in issue. So you see what is different from what's out there and what I have in my patent here. Three, you resolve the level of ordinary skill in the pertinent art. So you determine, what is a person that's familiar with this field, how skilled are they in putting these things together? How clever might they be in putting these different things together? And then four, you look at some secondary considerations. So I think if we go to the next slide here. So I think determining this level of ordinary skill in the art is maybe that's kind of that may be a little difficult to explain sometimes, but I think one way to look at it is that you would basically look at the types of problems that are encountered in the field, how have those problems been solved in the past, how often is innovation occurring in that field, how sophisticated is the technology in that field, and then like what level of education are the typical workers in the field. So once you start looking at the inventions that exist and then kind of considering what, how things are being innovated and how quickly they're being innovated, you can kind of get an idea of what the level of ordinary skill in the art is. And then, secondary considerations that can be taken into account would be things like commercial success of the products. That could be a secondary consideration. How it's being marketed, how it's being received. If it's very popular and selling very well, that might be an indication that maybe this wasn't obvious. So all of these things are then taken into consideration: the prior art, level of ordinary skill in the art, and these secondary considerations in determining whether or not your invention is obvious. So on the next slide, we have an example. Okay, here we go. So in example one, so this is going along with the chair theme of examples that we've already started with. So example one, you invent a chair with 4 metal legs to support more weight. So the difference is that the legs are made of metal. So the prior art only teaches that a chair has 4 wooden legs. So the determination would ultimately be that the invention is probably obvious because just a simple material substitution is generally going to be considered obvious. So then going on to example 2, so now you go out and invent a chair with 4 adjustable legs. And if we look to the prior art and we see that there are chairs with 4 adjustable legs, but they have a different adjustment mechanism than your invention, then you could come out and that would probably not necessarily be an obvious difference. Maybe the adjustment mechanism is different. Maybe your adjustment mechanism is easier or faster or more stable, whatever. Okay, so now on the next slide, next series of slides. So this is probably going to be kind of the start of the most important part of this, I would say. So what is the process of actually getting a patent? So basically first, before you even reach out to a patent attorney, I think you would probably want to sit down and assess whether or not the invention is actually marketable. The patentability would obviously be determined by a patent attorney, but you have to determine if this is something that you actually want to go down the path of patenting, or whether or not you need to patent it. So there are a couple optional steps you can go down after that. So you could next file a provisional patent application, which is essentially just stating the claim. Once you file one, it's kind of a low-cost option to preserve the priority date. You would basically be filing some documents describing the invention in some level of detail. You can do this as like a DIY thing, or preferably you would have a patent attorney go out and do this for you to make sure there's no issues. But once you file a provisional, you then have a 1-year countdown to file an actual non-provisional utility patent application. Next, you could file a PCT application, which is just essentially non-binding examination. This is a international application. It allows the applicant to postpone applications for up to 30 months. So it's similar to a provisional in that sense, but it's for the purposes of doing international filings. So then once you have actually filed your patent application, then that is binding examination. Everything that is, every letter sent to the patent office is going to be recorded and kept in this file wrapper associated with the patent. Every single examination round is going to require more time and money. So at the end of the day, average patent application or average cost of a patent application from start to finish, from date of filing to date of grant, is around $50,000. So that would make up, or that would be made up of attorney fees and then USPTO fees, and that could take between 3 and 6 years. So next slide. So this may be unnecessary at this stage, but in general, you are required to file certain information with the patent office to get a patent. So you need the title, and most importantly, you need your legal names and your residence and your correspondence address. The rest of the stuff, it's just kind of legally required. You have to show ownership, oath and deck, assignment documents, and then obviously the fees. So on the next slide. So the first thing that you'll probably do if you reach out to a patent attorney is they will recommend, or you will ask them to conduct a prior art search to assess patentability of the invention. So on the next slide. So by conducting this prior art search, you kind of, you'll determine what already exists out there. So to do a prior art search, you're basically telling someone, or you yourself are going to go out to Google Patents or USPTO.gov, and you're going to search and see what's out there. So prior art searching doesn't have to just be searching patent documents. You could be just, searching magazines, whatever, just looking around and see what's out there, and whatever is relevant, would be used in a determination of patentability, of assessing whether or not this thing that you're working on is novel and non-obvious. So I generally would recommend that it's, a very good idea to conduct at least a cursory, at minimum, prior art search. You don't want to be in a position where you end up investing a bunch of money in your invention and a patent for that invention, only to find that, it's been done a bunch of times, or there's like a very crowded, there's a lot of prior art that's very relevant. So, depending on the complexity of the invention and the number of hits, prior art search could be, $500, like a couple hours of time, an hour of time, to $50,000, just if it's a very, very complicated field with a lot of different stuff to sort through. So once you've made the determination that a patent is the way to go. So next slide. We have kind of a little sample timeline on the next slide of what it looks like step by step, what the process is. So in the blue boxes, I think that's kind of like the pre-filing stuff. It's kind of optional, not necessary, but so first step 0 really is you have your patentability prior art or freedom to operate searching, as we just discussed. And then the next step would be, you could file a provisional patent application. You could do a provisional patent application even parallel with the freedom to operate, just to make sure if you're going to be disclosing something publicly soon. And then, once you file your provisional patent application, you then have 12 months to file the patent, or to convert the provisional into a utility application. So now on the following slides, I have the US prosecution route and the international prosecution route. So US in green, and then foreign international prosecution in orange. So starting with the US utility route. So once you file your patent application, so up at the very top there, you have all your formalities taken care of. You have your drawings, your assignments, everything is all set, squared away. You've been working with a great patent attorney. He's prepared your figures, your claims, everything. So it's all filed. So once that's filed, within probably a year and a half to 2 years, depending on the area of technology that you're working in, you'll receive your first office action from the patent office. So an office action is basically a document that contains, best case scenario, it's going to be immediately a notice of allowance, which is rare, very rare. But most of the time, the vast majority of the time, overwhelming majority of the time, you're going to get at least a couple of rejections. So those rejections are typically going to be either a novelty rejection under Section 102 or an obviousness rejection under Section 102, 103. So once you receive that office action, your patent attorney is going to respond to the patent office. They have up to 6 months to respond. So the first 3 months, if they're able to respond within the first 3 months, there's no additional fees or anything. But after that 3-month period, every month there are extension fees, and they can get pretty expensive by the time you get to 6 months. If you don't respond within 6 months of that first office action, then the application goes abandoned and it's done. You don't want that to happen. So you respond to the office action ideally within the first 3 months. So that goes on over and over. The response to the office action is gonna tweak the claims. The idea is to get around the art that's cited by the examiner, and then eventually you're either going to receive an allowance or you're going to give up. We hope you don't give up. So on the international side, it's a very more or less the same process. You file your PCT applications. You then have 30 months to start doing deferred filings into other other jurisdictions. So that could be, you could do a Europe and EPO application. You could even do individual filings in specific countries, China, Canada. So you do all your patent filings. And then same as in the US, you're going to receive your office action, respond to the office action. They give you a little bit more time to respond through PCT. And again, that is repeated until either allowance or abandonment. So then on the next slide, so once the patent has been allowed, you then have to go out. So that's good news. Once the patent is allowed, you then have to go out and pay your issue fee in order to actually get the patent granted. So for the patent office, I think we'll get into this later, but the patent office has kind of a fee structure depending on the size of the company or the size of the person or the entity filing, I should say. So for like micro entity, that would be just an individual filing. Personally, that would be the lowest fees. And then, on the other side of things would be like a corporation or a large corporate entity filing that would have the highest fees. And I think as you scale down, it goes from, full fee to small entity to micro entity. It's basically halved every time. So once you pay your issue fee, patent issues, at some point before the patent issuing though, you have the opportunity to go out and file what are called continuation or divisional applications. So what that would actually be is essentially you can get another patent on some other feature that may have been described in that specification. You can't add anything new to it, but if in your specification, maybe your, if we're talking about chairs again, maybe your claims for your chairs that you ended up getting allowed are, adjustable legs and a seat, but in your specification, you also described having a back to the chair. Your continuation could then focus on a chair with a back. And then you would go through that same exact process as you just did. You receive an office action, you would iterate with the patent office until reaching an allowance. And then, after paying issue fee, and after the patent issues, there are, of course, maintenance fees that come due. It's in, I think it says 3.5, 7.5, and 11.5 years post grant. And then eventually 20 years from the priority date, the date of filing, the patent will expire. That's on the US side. On the PCT international side, it's a very similar process. Same deal. You have, once the patent allows, you also have to pay an issue fee. You also have time before the patent issues to go out and file your divisional applications. And then, once your patent is issued, you again have to pay annuities until the patent one day eventually expires in 20 years. So I think on the next slide, I have a little example of an office action. So this is kind of the first 2 pages of an office action, basically, before it gets into the meat of the rejection. But you can see, and just so everyone knows, this is all publicly available information. You can get this all on the patent office. We're not sharing anything that's confidential. But basically on the cover sheet there on the left, you can see that we have the application number. It has an indication of the filing date, has an indication of the first name inventor, and then it has some correspondence information along with the name of the patent examiner, the art unit they're in, and when the patent office was received. And then on the following, or on the right side there, you can see kind of like an indication of the type of office action this is. So that one right there is final office action. It has an indication of which claims have been rejected. Yeah, that's pretty much everything right there. I think they will typically also include like the phone number for the examiner if you want to reach out and speak to them, and then a description of the actual rejection. So it'll have the section cited by the examiner. It'll have a listing of the different prior art cited, along with how the application numbers or patent numbers for the prior art, which then you would use to try and ideally argue around or amend around. Okay, so next I think Doug is going to get talking about the patent term.
Yeah, thank you, Aris. Before we switch over, I did see a question asking if there are any low cost or no cost patent assistance in the St. Louis metro area. So I'm not actually aware of anything. If you go through some of the local incubators or accelerator programs, sometimes they will help with that, but usually there's some kind of exchange of there's some kind of deal associated with that. So unfortunately, I don't have any names off the top of my head. Okay, well, good. Just a reminder, if you have any questions, feel free to type them into the Q&A box, and we'll be happy to take them. So Aris has gone over kind of the mechanics of getting a US patent, and I'm going to just kind of mention quickly a few related items that are associated with US patents. So the number one thing is, how long is a patent good for? So US utility patent expires 20 years from its earliest non-provisional priority date. So the patent in general is good for 20 years. In some situations, you can actually extend the life of the patent, especially if there are delays in the examination process with the patent office. So if they're late on something, usually you can get some of that time back in what's called a PTA, patent term adjustment. And I've seen those anywhere from a few days or a few months all the way up to a couple of years. So that's a good thing. In other situations, for certain FDA regulated products, certain drugs or certain medical devices, again, because it takes time for the FDA regulatory process, the government will give you some of that time back in terms of a patent term extension. But in no cases is that ever more than 5 years. And again, it's very, very limited as to what products would qualify for that. And also on the flip side, if and sometimes your patent applications, the claims are very similar to something else that you have, So sometimes the patent office requires you to file what's called a terminal disclaimer, in which case that could potentially shorten the life of your patent. So it's you can get extensions and you can also get shortened terms. If we move over to the next slide, we'll talk a little bit about costs. Obviously, that's very important. So if you look at slide 38, I just kind of give you some ballpark numbers. So, typical lawyer answer, right? Well, how much does it cost? Well, it depends. It depends on a lot of things, but it depends on the complexity of the invention. It depends on, how long is your patent application. And it also depends on how hard the prosecution before the US PTO is. If you get a lot of rejections, it will take a lot more time and money to get that patent application allowed. So those are the things to think about. Just ballpark estimates. Again, these are based on just really average scenarios and also based on small entity fees. So to draft a patent application can range anywhere from $2,000, $3,000, $5,000 up to $20,000, $50,000 for very complex applications. For the kind of average mechanical invention, you're probably looking around the $10,000 to $15,000 range. Would you say that's about an average for software application, Arus?
Yeah, that's about right. 10 to 15.
Okay. Good. And then there are government fees for filing an examination. That's roughly about $1,000 for small entity. I think the exact number is $830. Don't quote me on that. And then there's the prosecution to grant, meaning, this back and forth process that Ari's talked about, where the examiner rejects it, you respond, you go back and forth until you either get the application allowed or you give up on it. And that can be anywhere from, just a few $100s. If you got the case allowed, first action allowance, then you would just pay the $500 issue fee and you can be done. Or you can go back and forth multiple times, and that can be, $15,000, $20,000 easy. And don't forget there are maintenance fees. Those are government taxes that you have to pay over the 20-year life at the 3.5, 7.5, and 11.5 year mark, and they add up to about $12,000 for a small entity. And then also that assumes that you're responding in a timely manner if you're not taking extensions or anything like that. If you do take extensions, there are extension fees that can add up very quickly as well. And sometimes you get what's called a final rejection, but final doesn't really mean final. If you want to keep things going, then you have to pay additional fees to keep the examination process going. So that's called a request for continued exam. You may want to appeal. If you don't agree with the examiner, you can appeal it. So there are costs associated with that. So, again, the ballpark costs for preparing, filing, and getting a patent allowed over its 20-year life is probably somewhere between $30,000 and $50,000 per application. Okay, and move on to slide 40. I just want to mention very briefly that there are some associated, so we're primarily focusing on US prosecution, but in many cases, you're going to want to seek foreign jurisdiction protection. So if you're considering filing in countries like Europe, Japan, those costs can be considerably higher than the US, so those have to be factored in to budgets. Other jurisdictions, Canada, Australia, the costs can be a lot lower. And also, again, don't just sprinkle salt all over it, meaning don't file in every single country, because those costs will add up very quickly. So you want to think very carefully, strategically, what are the important countries in which you want to seek protection for your invention. So things to think about, where you think you're going to manufacture or sell your product, where a competitor may manufacture and sell, what is the market size, things like that. So you've got to prioritize all of that stuff. Okay. Moving on to slide 42, I briefly mentioned maintenance fees in the US, but also if you file foreign patents, there are annual annuities. Again, it's like a government tax that you have to pay, and if you don't, your application will go abandoned, and it can be impossible or very difficult to revive those. depending on the circumstances. And so, for example, in Europe, those annuities over a 20-year life can easily be, $20,000, $25,000. All right, let's see, question just popped up. Let's see. If no ADS, what is the alternative? Do you just provide all the info in the letter? Okay, so an ADS is, I believe this person is referring to an application data sheet, and that's like a bibliographic sheet which provides all the inventor name, the titles, the priority, that sort of thing on a patent application. So usually you do file a patent application with this ADS, and that tells the PTO like everything they need to know about it, dates and things. If you don't, then you can file, let's see, the ADS controls. If you don't, I believe, and I'd have to look this up, so don't quote me on this, I believe the declarations would control for that information. So no, you can't just file a letter. You do need to file the proper forms to get the information into the system.
Yeah, that's right. And I think that USPTO does strongly encourage ADSs though. So if you don't actually file one, it's often the case where you'll end up speaking with the patent examiner and they'll request one. Yeah,
so definitely try not to do something that's out of the norm. Try to follow their normal procedures, because it just will make your life so much easier. Okay, let's move on and go over to slide 43. So I already talked briefly about, let's go back one, thank you. Talked about continuations and divisional applications. So I wanted to expand on that a little bit. So again, usually when we talk about patents, we usually refer to a patent family. So there's like a parent, a grandparent to the current patent, and then there may be child or grandchild patent applications. And so what that typically means is that you have a common patent application. So it has the same specification that discloses one or more inventions or different variations of those inventions. So one set of written specifications and one set of drawings. Or the family may include a common application, again, that same spec and drawings, that is filed in multiple jurisdictions. So you may file it in the US, you may file it in Japan, you may file it in Mexico. Or the family may include a common application that shares an earliest priority date, but will have different claims. So just a simple example, going back to the chair, maybe your first patent application describes a three-legged chair, a four-legged chair, a chair with a back, and a chair with the adjustable leg. So let's say there's 4 different inventions in there. So maybe the first application you file a patent and get it allowed on the 3-legged version. Then maybe you file a continuation or a divisional on the 4-legged version, and maybe you file another continuation on the seat back, and then a 4th one you could file on the adjustable leg part of it. So that would be an example of a patent family. And the beauty of the continuations, that allows you to claim things. You can only claim one invention in a patent, right? So the continuation allows you to claim things that you did not previously claim. Or if you don't like the claims that you got, you can try to improve them in the continuation. So it's kind of a way of potentially broadening the claims out, if you will. And the other thing about continuation practice is it keeps the patent family alive, it keeps it pending, and that way you can continue to preserve your IP rights, and you can continue to pursue additional claims. So continuations are very important, and they're not too expensive, but something to think about. All right, let's go over to the next slide and talk about patent validity. So, Maurice has done a great job of telling us how to get a patent. So now you have your granted patent, and you can say, yay, I've got, I am the owner of the 123 patent. And the beauty of that is there's a presumption of validity of that patent. Okay, so if you get in any legal action, you start out with the presumption that your patent is valid. Unfortunately, just because you have a granted patent doesn't necessarily mean it's valid. Somebody can always challenge the validity of that patent. So it can be knocked out for obviousness reasons. It can be knocked out for novelty reasons. There's some other things that can also be used. So that can be challenged either administratively through the U.S. Patent Office. There's a time limit for some of those actions. Or if you're involved in litigation, you can also challenge the validity of a patent in the court system. So that's something, you know, if you are involved in patent infringement, so that will most likely come up as one of the defenses. Okay, so let's talk a little bit very briefly about litigation. Again, you know, our focus today is on getting the patents, but once you get it, you may need to use it as a sword against someone. So on slide 45, we have a real quick overview of that. So if you believe a competitor or someone is infringing your invention, your patent, then you know you can hire litigation counsel and file a patent infringement claim against that defendant. And just so you know, all patent infringement cases start out and go through the federal district court system because it's controlled by federal law, so you're not going to be dealing with state courts. Most of these cases are settled out of court in terms of, you know, some kind of royalty or money payment. There may be a cross licensing. There's any number of ways to settle these things, but most of them are settled, and that's usually the most economic way to do it, and the one that you know, provides the least amount of heartburn. But in some cases, these cases do go all the way to trial, and if they do, they are going to cost millions of dollars and take several years to resolve. And even then, they may be appealed, in which case they go on to the federal circuit, and they may even go all the way up to the Supreme Court if these cases involve some fundamental constitutional issue. So patent infringement is a very long and costly process, so you know, be aware of that. Let's move on to freedom to operate on the next slide. And again, we've talked about getting patents today, but again, it's a little bit of a paradox, if you will. Just because you get a patent does not mean that you are not infringing someone else's patent. So, you know, to boil that down very simply, patents do not infringe other patents. So you have an invention, you get a patent on it. If you're not making it, you're not using it, you're not selling it, you're not offering to sell it, then you just have a patent, which is an idea that's protected, and that does not infringe somebody else's patent. But once you start actually practicing that invention, making, using, selling, offering to sell, that's when you potentially could be infringing somebody else's patent. And why is that? Because somebody may have patented an invention that is broader than what your invention is. Your invention may be improvement over something, the better mousetrap, so to speak. And that earlier patent may still may be around, it still may be enforceable, and it may have claims that are broad enough to cover what you're doing. So what do? You need to do some freedom to operate searching to check that out and make sure you're not infringing. And it's a very complex analysis, so that's something that we definitely recommend that you work with patent counsel on to determine whether you're infringing, whether you have freedom to operate. Okay, let's just go through a quick example so we can kind of illustrate the point on slide 47. So example one, let's say, again, going back to our our favorite chair here. Let's say your invention is a four-legged chair with a back support. And there is an earlier patent that has a claim covering a chair comprising three legs. So the key here is the word comprising. There's actually has legal meaning, and your four-legged chair invention would literally infringe the earlier patent because the claim says it comprises three legs. And the legal meaning of that is that the patent covers any three or more legged chair plus any other components or elements in that chair. So that's what's called an open transition or open claim. The next example, let's say you have your invention is a three-legged chair with a back support, and the earlier patent only claims a chair comprising four legs. So that means the chair that's covered by that earlier patent has 4 or more legs, right? So it doesn't work backwards. It doesn't cover the 3-legged version, and therefore you would not be literally infringing that patent. So again, some very simple examples. We're getting close to the top of the hour, so I'll just kind of race through these next couple slides really quickly. Patents and fundraising or exits are important. Investors or strategics that are looking to acquire companies in certain industries, mechanical type of inventions, biotech, pharma, sometimes in software, definitely in medical devices. They want to look at your patents during fundraising or an exit strategy. They want to make sure those patents actually have claims that cover your commercial product or whatever you're doing. And so you should be able to distinguish your invention from the prior art. And they're going to ask about a whole bunch of other things during IP due diligence, including ownership of the IP, freedom to operate, the validity, et cetera. So, be prepared if you are trying to raise money or go through a merger acquisition, that IP will be something that comes up. Patent ownership on the next slide. By default, the inventor owns his or her invention, unless there is an assignment or an obligation to assign the invention. So in the US, most companies typically require their employees to assign inventions that are related to their job function. Same thing if you're a university faculty staff, typically most universities require faculty staff to assign inventions to the university. So you got to really check out your employment or consulting agreement and see what your obligations are, make sure you understand that. And then ownership is of course perfected by executing an assignment document and then reporting it to the patent office. So same thing when you buy a house, right? You get a deed and you record it with the county registrar's office. So same thing. And then just, a good word of practical advice is try any signatures for any of this stuff, try to get them properly, because people come and go, it can be hard to find. Sometimes they get disgruntled and then they don't want to sign things and it just makes things more complicated. And let's move on to slide 50 real quick. So you've got your patents. So what do you do with it? Well, you probably want to monetize it. So there's a number of things you can do. You can exploit the patent, meaning you can practice the invention and try to sell the product and block others. You can license the patent, you can sell the patent. So patent rights are like a house, right? Real estate, you can own it, you can rent out part of the house. If you license it, you can grant whatever, you can slice it up however you want. It's kind of like you can put fields of restricted to fields of use. So your invention is only good for use in this following area. You can put geographic limitations on that, or any other conditions that you can think of in a license. So licensing is a good way of monetizing patents if you're not interested in actually exploiting the patent. And finally, I'll just talk very briefly about portfolio management and say on slide 51 that intellectual property and patents are kind of like having pets. Pets, you gotta bathe them, you gotta feed them, you gotta take them to the vet, you gotta take care of pets. Same thing with pets. They require a lot of tender, loving care. So you need to manage the portfolio in order to, manage costs, make sure you're not spending money that you don't want to. And so that stuff needs to be reviewed and managed like anything else. So with that, if we can just go to the last slide, I want to thank our audience. If there's any questions, speak now or forever hold your peace, type them in the Q&A box. We're happy to address them. We do appreciate your feedback. We do listen. We would definitely love to come back next year. So if you can scan that QR code and fill out the survey, we'd love to hear what you liked, what you didn't like, areas for improvement, that sort of thing. Again, thanks to my colleagues, Aris and Michelle, for helping put this together. And I hope everyone has a great day.